He's currently a reader in King's College London and author of Courts in Conflict, Interpreting Layers of Justice in Post-Genocide Rwanda, as well as several papers and on international law and crimes, resistance to mass violence, methodological approaches in transnational justice, and legal pluralism. She was before that here as a global research fellow in St Anne's, and she also did a DPhil here, so it really is welcome back. So enough from me. People come to listen to you, so the floor is yours.
Wonderful. Thank you, Ian. Thank you to everyone here and to the centre. It's wonderful to see familiar faces, but also really to have this opportunity to share some ideas on what for me is quite a new project. And it's also a project that's in flux, because one of the things that I'm looking at in the UK case, we're seeing a lot of legal change. We've seen the Court of Appeal today hearing the final hearings on the legality of the Rwanda UK immigration deal, and yesterday we saw the illegal immigration bill passed through the Commons. So it's the social space that I'm looking at is in flux. And this is a new project, so really I would very much like this to be an exchange, and I very much welcome your input. And in preparing for today, it took me a while to realize that really what I had been trying to do was present what I hope will be a book project in 45 minutes, and then realizing that given that it's not a book project yet, doing it in 45 minutes was really not feasible. So instead, what I've tried to do is cut it down and focus on a smaller aspect of what I hope fits into a larger project. And in thinking about that smaller aspect, the paper is going to begin with a description of two courtrooms, although the broader title I have is Race, Refugees and International Crimes, Rwanda's role in the transnational legal ordering of criminal justice. But I'm going to start with this description of two courtrooms. And in each of these courtrooms, different English judges have been called on to assess the legality of forcibly sending people to Rwanda. In the first, in 2017, this forcible transfer was found to be unlawful. In Rwanda versus Inteziriyayo, the case that came before the court was a decision in which the ultimate outcome was not the decision not to extradite Rwandan genocide suspects from the UK to Rwanda. The Divisional Court found that the Rwandan Criminal Defence Council were, and I quote from the judgment, not suitably experienced and resourced so as to ensure that the individuals being transferred would not be at risk have a real risk of a flagrant denial of a fair trial. And I will go into this legal decision-making and who was in that courtroom in some detail. The second fast forwards us through to 2022, and here a differently constituted divisional court found forcible transfer to Rwanda to be lawful. In the current judicial review in the UK's new the UK's new asylum policy, the divisional court has held that the diplomatic assurances from the Rwandan government are sufficient to ensure, and I quote from the bilateral agreement, access to independent and impartial due process for the people seeking asylum has been secured through this bilateral agreement between the UK and Rwanda. So in describing these courtrooms and the legal arguments raised within them and the judgments that have come out of them, what I want to do is actually draw attention to how Rwanda as a place has been racialized in these proceedings and the problematic implications of this for legal change, both in the UK and in Rwanda, where we've seen this strong focus on the safety or otherwise of Rwanda and the asylum processes there, leading to a shift away in the legal arguments from the UK's obligations to people fleeing conflict or persecution when they arrive on these shores. Now, I want to develop this argument in three parts. In the first, I want to try to draw you into these two English courtrooms, showing the different legal issues that are at stake and the people involved in determining them. I want to highlight the different orientations of audience when we're looking at discussions of the UK government sending people to Rwanda when the concerns relate to the extradition for a charge of an international crime, as opposed to the externalization of the UK's obligations to process asylum applications. So I want to try to draw particular attention to the different audiences that are being addressed and how, when the focus is on Rwanda, we can see that these cases are deeply entangled with one another. Then in part two, I then want to draw on some of the current writings on race in international law as a means to start to think through the role of law in racializing what Anthony Angie would call the gap between civilized and uncivilized societies, and then immediately offering the techniques to normalize, in his term, the aberrant social order. And then finally, in part three, I want to return to those courtrooms and their legal decisions to see the work of racialization within these proceedings. Taking seriously the role of racism in these courtrooms and the decisions that have come out of them, I want to suggest prompts a new direction for inquiry into questions of racial justice that focus on law's role in enabling the movement of people. So, to that first courtroom, sorry, this is actually me telling you what I was, 4 points rather enthusiastically. Let me now take you into those courtrooms. The lure of slides here has been because I think the visuals are important because they contrast quite sharply. So in the first courtroom, we were in Westminster Magistrates Court on Marylebone Road in London. And the case being heard on that 15th of June 2015 concerned these 5 Rwandan nationals accused of organizing, encouraging, and in the case of 2 of the suspects, directly murdering people during the 1994 genocide against the Tutsi. Now, when I arrived, it was quiet outside the courtroom. No members of the press were present. The atmosphere was that of the everyday work of lower courts. In the build-up to and following the decision, there was limited media coverage in the UK with cursory articles on the BBC News websites and in the Evening Standard. Yet the first people when I saw on entering the courtroom, both of whom I know well, were senior officials in the Rwandan government. First, I greeted John Bosco Sibiyontore, the head of the Genocide Fugitive Tracking Unit, a special branch of the Rwandan National Public Prosecution Authority, followed by Florida Kapasinga, a prominent Rwandan lawyer who previously served as a senior legal advisor to Rwanda's National Public Prosecuting Authority's International Crimes Unit, and he had also previously worked in the Office of the Prosecutor for the United Nations International Criminal Tribunal for Rwanda. Soon they were quickly both on their phones, talking quietly. These cases were highly significant to the Rwandan government and were covered extensively by the New Times, the English language government-run newspaper in Rwanda. Ultimately, the extradition request in the Westminster case was denied. The Deputy Senior District Judge reasoned that, as I said at the start, there would be a risk of a flagrant denial of a fair trial, which turned on the lack of availability of suitably, and quoting again, suitably experienced and resourced defense counsel in Rwanda, without whom there was a greater risk of judges behaving impartially and being influenced by factors outside the evidence. Now, it's important to note that in the magistrate's decision, these cases concerning genocide suspects were explicitly differentiated from cases, and I quote, with a political flavor. They were understood to be less influenced by political pressure than some cases brought against current Rwandan political opposition and government critics. The decision was upheld on appeal, And here, Lord Justin Irwin and Justice Foskett, sitting in what was then the Queen's Bench Division of the High Court, went on to state, the arrangements for defence in Rwanda are clearly inadequate. And they go further, in an authoritarian state where judicial independence is institutionally weak and has been compromised in the past, where there is established fear by witnesses, not all of which can be effectively countered, the existing arrangements for defence counsel are quite insufficient to ensure a reasonable fairness in the proceedings. So this was the crux of the decision, and the 5 respondents were released. Now, at this stage, what I want to suggest in this case, that there are at least 2 different audiences that are at play. So one is UK oriented and is addressed in the judgment itself. The Divisional Court affirms its own fair trial standards in line with Article 6 of the European Convention on Human Rights through the assessment of the failure of the Rwandan legal framework and its personnel in particular to meet those standards. So it's focused on one state's assessment of another state's criminal justice system. The norms being generated and asserted in this extradition case relate to a state, often, and in this case in the global north, looking towards another state's practice, often, and in this instance, in the global south. The other audience is very strongly Rwandan. So these cases, as I said, matter deeply to the current Rwandan government, and they form part of an extensive push to pursue genocide suspects around the world. So since 2014, I've been mapping the deportation, extradition, and domestic trials of Rwandan nationals alleged to have participated in the 1994 genocide against the Tutsi. And to date, I've developed a data set of 102 individuals engaged in litigation in 20 countries around the world. So this is one, for the Rwandan government, this is one case among many. And the pursuit of genocide suspects has been pushed by survivor groups and diaspora groups in various countries and by proactive efforts from the Rwandan government, sometimes in collaboration with, for example, Interpol. And it's been pursued for multiple reasons, as I say, sometimes pushed by survivor communities, but also what it is enabling is the Rwandan government to extend the carceral reach of the Rwandan state into its diaspora communities. So this Rwandan diaspora is a crucial invisible audience, where the pursuit for accountability for those involved in the genocide intersects with and enables the Rwandan government to reach its carceral control outside of its national borders. So the trials in that sense serve a security agenda in which the transnational legal orders of criminal justice and immigration law operating together are drawn on by the Rwandan government to unsettle political opposition. And as a result, Rwanda has become increasingly embroiled in the immigration regimes of Europe and North America. And this has resulted in a network of lawyers, politicians, and government advisors and border control officials engaging very closely with Rwanda. These extradition proceedings in 2015 and going through to 2017 form part of what, in the second case I'm going to and the second courtroom I'm going to draw you into, describes as the experience of bilateral relations extending over almost 25 years between the UK and Rwanda that are drawn on to underpin the recent asylum arrangement and the High Court, well, the Divisional Court's decision that arrangement is lawful. Although, as we know, that decision is currently under appeal, and I have been in those courtroom hearings since Monday, and so I will talk also about how those arguments are changing and the grounds for appeal in the case. But keeping this in mind, I now want to turn to that next courtroom. And you can see that I have prepared this without, there we go, this was into the next courtroom. So on the 5th of September 2022, the atmosphere outside the court was notably different to that of 2015. The case before Lord Justice Lewis and Justice Swift of the Divisional Court concerned, as we know, the judicial review of the current UK government's policy under which people seeking asylum in the UK can be removed to Rwanda. In April 2022, the UK government announced a migration and economic development partnership for the provision of an asylum partnership arrangement, APA, with the Rwandan government. Under this arrangement, people seeking asylum in the UK whose cases are deemed inadmissible under the immigration guidance that was applicable at the time, or if the illegal immigration bill comes into effect, would be deemed ineligible, will then to apply for asylum in the UK, will then be sent to Rwanda to have their asylum claims processed there. If successful, if these individuals are successful in that asylum claim, the understanding or the stated intention is that they would then live in Rwanda in the long term. The APA is underpinned by a memorandum of understanding and notes verbal disclosed in the litigation, under which the UK and Rwanda make a number of promises, particularly on how individual asylum claims will be considered by the Rwandan government. The first removal flight to Rwanda, scheduled to take off on the 14th of June 2022, and I'm sure this is familiar to everyone in the room, but I think it's important grounding, was grounded on when the European Court of Human Rights issued a Rule 39 interim measure in a number of individual cases requiring the courts of England and Wales to issue a final domestic decision on the policy's legality. So it's the UK government's current position that no flights will happen until the legal proceedings are concluded. So as I walked into the Royal Courts of Justice, an elderly man with a placard reading "Stop Rwanda" politely moved to the side of the crowd. "We're not here to stop access," he earnestly assured me. By lunchtime on the first day, there was a large crowd of protesters outside, who enthusiastically cheered as the prominent British commentator Gary Young addressed the crowd. And alongside the "Stop Rwandan" placards, there were now signs with a slightly different orientation: "All refugees welcome," "Oppose offshore detention," "Stand up to racism." Walking up the stairs to courtroom 76, I chatted to one of the trustees from Care for Calais, which was one of the NGOs that was one of the 11 claimants involved in the case. He shook his head and muttered, "It's the same judge, we're not very optimistic." Outside the court, a small group of counter-protesters angrily told those leaving the court to stop their fucking virtue signaling. At lunchtime on day 2, a young woman lay across the entrance to the courtroom, forcing the lawyers to step over as they entered the court after the lunch break. "Think about what you're doing," she pleaded. Most of the lawyers were acting for the complainants and did their best not to pay her any attention. In contrast to the Westminster extradition case, there was not a single Rwandan present in any of these oral hearings. Throughout the week, including in the spillover courtroom, the absence of any Rwandan government representatives was notably different from all of the extradition and deportation cases that I've previously observed. Such absence has continued in the appeals court proceedings. As the first claimants articulated in their written skeleton arguments, no direct evidence has been filed by any representative of the government of Rwanda in these proceedings, and there's been no application to intervene from the government of Rwanda to address the criticisms that have been made of it. So the first audience for this judicial review and the social space in which it's happening both inside and outside of the courtroom is strongly UK oriented. While the UK's Rwanda policy has been one of the major political policies of this current government and a driving force behind huge levels of statutory change, seen in the Nationality and Borders Act of 2022 and now in the Illegal Immigration Bill, an understanding of what is happening in Rwanda and why it's involved in the UK migration deal is notably absent. In the proceedings up to now, there have been no Rwandan experts called in the case. All evidence about what is happening in Rwanda has been based on secondary evidence provided in written form by predominantly UK government representatives. On day 1, Judge Lewis interrupted the claimant's submissions and asked, if we have a problem with Rwandan law, who are we to sit in England and Wales to make a determination on that law? There's silence in the courtroom. Although it's unclear whether, then he asks, are the laws published in all 3 languages in Rwanda? Here we have special rules for when the text is published in Welsh. Again, there's silence in the courtroom. Although it's unclear whether this is arising because no one knows the answer or it's too impolite to say. Regardless, the silence is endured briefly and then the proceedings continue. The court did not want to engage too closely with Rwanda and what's happening there. This is now a central point of arguments in the appeals proceeding currently happening, and where one of the grounds of the current appeals addresses whether the divisional court sufficiently scrutinized whether the Home Secretary had engaged in a thorough examination of the asylum process in Rwanda and the independence of the Rwandan judiciary more broadly. And then in the oral hearings that I attended on Monday, again, we had a point where the bench asked, how many lawyers are there in Rwanda? Of which the response was immigration lawyers or other lawyers. And then the bench said, both would be good to know. Again, there was silence. We can find out for you, my lord. Rwanda, and this is the key point I want to make here, Rwanda is standing in, imagined by those designing the policy, either as so awful as to act as a deterrent for those pursuing dangerous journeys across the English Channel, or so it both deters, or it is at the same time a sufficiently safe third country that is well placed to meet all of the UK's legal obligations as a signatory to the 1951 Refugee Convention. And sustaining this duality requires that Rwanda is a symbol rather than an actual place. And it results in and relies on a deep racialization of Rwanda. Now, as a white scholar writing on race, one must necessarily be circumspect and reflexive. Not as a confessional act of white privilege, I would hope, but rather as one of orientation. And so, as a starting point, I want to return to Steve Biko's challenge to the white liberal South African, to speak about racism within white spaces. How might we try to understand racism within spaces that are predominantly white? Because racism looks different in different places. Now, through a detailed discussion of the Sudanese context, which of course is hugely timely, given that that at the moment Sudanese refugees would not have no access to claim asylum in the UK. Eddie Thomas has done some really important work there on racialization, and he proposes understanding racism as the dynamic and politically usable histories of social difference that establish and continue relationships of subordination and domination. And he juxtaposes this understanding again, in contrast to how international criminal law's constraints in understanding these categories in terms of who fits into the protected group of a protected group within the Genocide Convention, which in terms of legal doctrine has to either be objectively or subjectively determined as those people belonging to a national, ethnic, racial, or religious group. So for Thomas, what we see, he uses this and incorporates into this definition an assessment of the material conditions that structure relationships of subordination and domination. Drawing on similar historical materialist frameworks, Tina Zavala describes racism in the following terms: as a modality of stratifying populations that arose in tandem with capitalism and imperialism and enables the grabbing of land and other resources, as well as super exploitation of the labor of racialized people. For Zavala, this definition demands a dynamic understanding of racism and racialization. As capitalism evolves and changes, so do processes of racialization and racism. And it prompts an examination of race in particular places that nevertheless takes careful account of the transnational dimensions of these constructions and the material implications of the racial stratification. And so this is my concern in attempting to understand how Rwanda as a country is racialized within the UK courtrooms and the implications of this for legal change in Rwanda and the UK. It was following the individuals who stand accused of involvement in the 1994 genocide that brought me into those two English courtrooms. The courts are addressing very different audiences, but the cases have become intimately entangled. As George Marcus usefully alerts us, ethnographies, which are so deeply committed to understanding the local, can offer us a way to illuminate world systems. For Marcus, a series of modes of construction, the tracing of people or things or metaphors or conflicts, offers a route to design multi-sited ethnographies. And so to draw on his ideas, these strategies of quite literally following connections, associations, and putative relationships offers the foundation to access the various places where Rwanda's post-genocide justice seeking continues to have effect outside of Rwandan borders. And doing so shows both the normative aspirations of this and how the racializing work of criminal law can feed into wider global systems of governing the movement of people and its resultant injustices. The Rwandan government has been actively pursuing genocide suspects in the UK for many years, and in doing so, it's increasingly embroiled in the UK's immigration regimes. President Paul Kagame, in his first address after signing the APA, is well aware of this connection, and it helps to explain why the migration deal was reached with Rwanda in the first place. In his first public address after the conclusion of the APA, he directly addresses the connection between the potential transfer of refugees to the need to send back the 5 genocide suspects from the UK. In his words, in a clip shared widely on social media, he said, "In fact, I hope in the UK when they send these people, they should send to us some of the people they've accommodated for over 15 years who committed crimes here." In this account, the diplomatic relationships that underpin the APA are the same ones that shape the cooperation over the extradition requests. Tracing Rwanda's pursuit of genocide suspects highlights the increasing overlap of immigration law and international criminal law, and it tells a wider story of Rwanda's role in the transnational legal ordering of criminal justice and the complex recursive relationships between international and national lawmaking. The resultant trials are argumentative sites with very serious punitive outcomes for the people concerned, notably their forcible deportation. Recognizing these entanglements then prompts a further analysis of how writing on race in international criminal law can shed light on racialization within those courtrooms. So drawing on the earlier work of Mikhail Matur, Robert Knox has highlighted the specific racializing work of international law. For Knox, both settler practices of colonialism and in contemporary settings, the competition among imperial powers, explains how the development of international law draws explicitly on racialized capital in Knox's analysis to pursue capital gains. The binary logic of this racialized other creates a bright line between those that are civilized and those that are uncivilized. And I think here Anthony Angi's earlier work on colonialism then crucially shows how international law can then provide the civilizing bridge, offering the legal techniques to normalize the aberrant society. Now, as I've previously suggested in some of my earlier work, I think this is strongly reflected in international criminal law, where neo-colonial critiques of the prosecution of targeting African states are then responded to by highlighting how a number of African states are actually that are signatories to the ICC's Rome Statute, and how the situations under investigation in Uganda, the DRC, and the Central African Republic and Mali were initiated through referrals from these states. So these this response is entirely consistent with how international law helps to construct racialized categories of the Black, African, or Arab defendant, and then immediately offers the legal techniques through which African states can normalize the aberrant societies. This is not to negate the specific political and legal drivers for these referrals, as Phil's work shows, where there are particular drivers from those African states themselves. But rather, what I want to do is draw attention to how the current practices of international criminal law express deeply racialized understandings of where and by whom these types of crimes are committed, and offers criminal law as a means of redemption. So, as Knox has recently argued, in our current global setting, the international institutions of the International Monetary Fund and the World Bank have played a significant role in restructuring the economies of the Global South to facilitate the continued movement and accumulation of capital, at least in part, and this is what's key to his argument, through mobilizing racialized discourses as to the laziness and ineptitude of such states and the corrupt and kleptocratic nature of their leadership. Within this wider structural setting, international criminal law plays its part through charging, in some cases convicting, these same leaders for international crimes. As Knox writes, while Creever and Marx are certainly correct to stress that the language of international criminal law and international human rights law displaces root causes to focus on monsters, we might note that the ability to portray certain individuals as monsters often relies on racial stereotypes about the propensity of Black people towards violence. So why talk about this? What I want to suggest is that understanding the process of racialization in this way allows us to start to see how law then offers the techniques to redeem the, to use Angie's phrase, aberrant society. And so what I want to do is take that insight, given these ties of seeking genocide suspects, and then the role that particular case then plays in these current extradition proceedings. I want to take and work with some of these ideas around how racialization occurs, and then the role that law then plays in it, to help us, or at least to think, for me to think with, in returning to those courtrooms. So let me try to do that now and see where it takes us. So back in the Royal Courts of Justice, inside the Divisional Court, what I want to suggest here is that racialized imaginaries have informed the legal arguments of both the UK government and the claimants. And this becomes more visible if we look at how the decision in Rwanda versus Inteziriayo that denied the extradition to Rwanda has been used in the arguments put forward in the judicial review. So in the 262 pages of the skeleton arguments submitted by the lawyers representing the first 8 and the 10th claimants, the extradition decision is referred to 5 times. The first use is to draw attention to the need to treat assurances by the Rwandan government with caution. The claimants argue that there are good and obvious reasons to treat the material adduced from, provided by the government of Rwanda with caution, particularly given the nature and extent of the human rights criticisms raised in the High Court's decision. Second, it's used as evidence in a section on additional human rights concerns to support the central concern regarding the risk of harm to those who express political dissent against the Rwandan government. And this includes concerns over extrajudicial killing and forced disappearances of political opposition. And third, and this has become the most important, it's been used to challenge the independence of the Rwandan judiciary, drawing on how the court described the Rwandan regime as clearly authoritarian. And the relevance of this for people sent from the UK to claim asylum in Rwanda is that their final point of appeal for individual refugee determinations is the Rwandan High Court. Now, When the claimants first referred to the extradition decision, Judge Lewis seemed genuinely surprised and reached for one of the many files to look for the case reference. The next day, the lawyers acting for the government directly addressed the need to differentiate the two cases and made the following statements during the oral proceedings. This decision should not be made on the basis of the English court's judgment in the extradition case. The central concern there was, if you send me back to face charges for murder in the genocide, you'll be judged by people who are part of the same ethnic group or tribe who were killed. This is the context. So the explicit reference, and again, this is the same reference that emerges in the arguments that happened yesterday in the Court of Appeal, in which the argument to differentiate those two decisions is that that case was, and I quote from yesterday, it was about tribal opponents, as it were, who were being transferred back. So this is a huge simplification of the extent to which judicial independence in Rwanda may or may not be established. The ethnic makeup of the Rwandan judiciary was not the basis for the initial magistrate's decision. Rather, it was the presence of sufficiently trained defense counsel. And the magistrate was at pains to state that these cases concerning charges of international crimes were distinct from political cases. The divisional court when the divisional court upheld this reading, although they were more receptive to the wider challenge of judicial independence raised by in the Rwandan context, the point that I want to draw attention to here is that the lawyers acting for the government offered the judges a deeply racialized way of differentiating these cases. Since Prunier's the Rwandan crisis, closely followed by Alison Deforge's Leave None to Tell the Story, social scientists have been at pains to argue for understanding the violence of the genocide not as an instance of ancient tribal hatred, but rather as of clear political intention underpinned by racialized colonial governance, economic pressures, and political and social mobilization. Yet in the London courtroom, the essentialized and racialized position is easier to reach for. Race is an easier tool for understanding difference. In the divisional court, in this, as we know, in the decision by the divisional court, the efforts by the claimants to use the extradition decision as a basis for factual claims about Rwanda was summarily ignored. On the 19th of December 2022, when the King's Bench handed down its decision, there's no mention of the Inteziriayo decision. It ruled that it's lawful for the government to make arrangements for relocating asylum seekers to Rwanda and for their claims to be determined in Rwanda rather than the UK. The court was at pains to deal with evidence concerning Rwanda as minimally as possible and instead relied heavily on the value of diplomatic assurances and the behavioral effects of the financial incentives that the UK has attached to the APA. But in the oral proceedings that are currently happening before the Court of Appeal, the extradition decision is once again front and center. The independence of the judiciary is crucial to the structure of the APA. And so what we end up again is this with a highly essentialized and not very deeply informed in terms of the evidence that was provided to the divisional court account of what's happening in Rwanda, where on the one hand, the claimants are saying the RPF exerts absolute control over the judiciary, and the other, the government saying it's about tribal opponents, as it were, being transferred back. And I'm quoting again there. So the decision of the APA, coupled with the Nationality and Borders Act and the Illegal Immigration Bill, has what I want to suggest now for this final section is that this racialization has very serious implications for legal change, both in Rwanda and in the UK. And here, Angi's ideas about how law then offers the techniques to civilize the aberrant society, I think can be helpful in illuminating this. Because in the commentary to date, it's been assumed that the deal is good for Rwanda. It's been assumed that Rwanda has received £140 million from the UK government, and the assumption is that this is in Rwanda's interests. However, the wider concern about the racializing work within the literature on international law, I think, helps us to reorientate this appraisal. Rwanda, set up as the aberrant society and in line with racialized constructions of international law, can always be redeemed by more legal change. In particular, it's highly likely that what we will see, that driven by the APA, whether or not anyone is transferred from the UK, and I think we should assume that those transfers will happen. I think it's complacent to think that they won't. Rwanda will invest substantially in an individual refugee determination process, including, as disclosed in the litigation over the last 2 days, through the creation of a new special immigration court. Up until now, Rwanda has run a broader and arguably more inclusive approach to refugee status determination on prima facie status. This is underpinned by a longer history of both experiencing displacement by those currently in power and showing a commitment to being open to refugees. For the 130,000 refugees currently in the country, this status has been determined automatically based on the place where they came from. They have prima facie refugee status. And thus the places they have come from, of those 130,000, 96% are coming from Burundi and the Democratic Republic of Congo. Individualizing refugee determination, as required by the UK scheme, may not be in the best interests of the majority of refugees who enter Rwanda from these neighboring countries, because I think it will either result in a two-tiered process where the state only recognizes obligations to certain refugees. These special refugees will be housed, and the housing was actually appropriated from a private housing development, certainly the housing that Suella Braverman was pictured in. And as disclosed through the current litigation, the Rwandan government will receive funding for 5 years to meet these refugee needs for everyone whose status is recognized through this individual refugee process, which is getting spoken about as this bespoke deal. So either we will have a two-tier system where some refugees are able to make these claims and have this provision and some won't, or we're going to see an increasing restriction in recognizing refugee status generally inside Rwanda, which will inevitably result either in backlogs in those processes or incarceration, or potentially in incarceration. In addition, the focus of the litigation in the UK will prompt in Rwanda, I think, further investment in human trafficking related law and policy making there. Under the proposed illegal immigration bill, whether or not someone is trafficked will no longer be determined by the UK. It will be for Rwanda to determine this and to offer protection for victims of trafficking. Now, I think for years, scholars have alerted us to how in practice, trafficking laws developed at the international level have resulted in tighter control at the border and have restricted the potential to make asylum claims. And I'm thinking of some of the earlier work by James Hathaway here and some of the current work by Prabhat Tisran. The major outcoming of the civilizing endeavor of the individual refugee determination process and the greater focusing on anti-trafficking law, I think in the Rwandan context, is going to be increasingly coercive border control by the Rwandan government. In addition, then, I think what we've seen is the focus of the litigation has been on the safety or otherwise of Rwanda, and less of the legal argument, although some legal arguments have been raised in this regard, and I'm happy to talk about them further. But generally, the attention has been on the safety or otherwise of Rwanda. And instead, I want to draw attention to the arguments over the compatibility of the APA with the Refugee Convention, and how limited a interpretation of the Refugee Convention has been provided in the case. And I think really the racialization of Rwanda has very serious legal implications for the extent to which the focus has been on whether the UK is meeting its obligations under the Refugee Convention. Because in its judgment, the Divisional Court read its international legal obligations extremely narrowly, and relied heavily on the MOU and the notes verbal underpinning the UK agreement with Rwanda as being sufficiently specific and detailed. I'll give you the quotes from the judgment itself, from paragraph 121, where Mr. Drabble KC, and this is the broadest argument that was raised in the litigation. Most of the litigation up to now has focused on the safety or otherwise of Rwanda, also in relation to the Refugee Convention, because under the arguments in relation to whether or not it constitutes a punishment under Article 33, sending individuals being sent to Rwanda would still have to constitute that punishment. So the broadest argument was submitted by Mr. Drabble and he argued that the Refugee Convention imposes an obligation on contracting states to determine all asylum claims made on their merits. So this is the argument, that the UK has an obligation under the convention to determine the status of refugees on arrival on the shore, so that if they are an eligible refugee when they arrive in the UK, there is an obligation on the UK government to determine whether or not they are refugees, because if they are refugees, then all of the obligations under the convention arise. Now, the court said, we disagree. There's no such obligation on the face of the convention. The obligation that is imposed is the one at Article 33, not to expel or return a refugee to a place where his life or freedom would be threatened by reason of any of the characteristics that the convention protects. This is a very narrow protectionist obligation, in which if an individual is sent to another safe third country, that obligation is met. Now, that has not received with it the same level of attention as the question of the safety or otherwise of Rwanda. In many ways, the fight for or the argument around whether only this narrow protectionist obligation arises has not been the focus within the legal proceedings to date. But but as David Kando has said in the commentaries in relation to the illegal immigration bill, if the treaty only prevented the removal of refugees to a country where they feared persecution, every country in the world would spend all its time trying to ship its refugees to other countries. In rejecting a wider purposive or functional reading of the convention, the Divisional Court stated that Mr. Drabble's submission was that an obligation to determine asylum claims would be consistent with the spirit and purpose of the convention and would therefore reasonably be assumed. And the court went on to say that, again, we disagree. An obligation to determine every asylum claim on its merits would be a significant addition to the Refugee Convention. Now, there's an important discussion here regarding how the court has engaged in an originalist understanding of treaty interpretation underpinned by judicial deference to the executive's interpretation of international law, particularly the interpretation of the UK's compliance with its own international commitments. In other words, that this treaty, that it's a very, that there is certainly the possibility of arguing for quite a lot of support for either a functional or purposive interpretation of these treaties, but it's not an argument that's generally being addressed in very much detail in the litigation. But what I think, for the present purposes, what I want to do is return to the role of race within this. Migration and refugee law is one of the sites in which the racializing work of international law is particularly visible. To draw on Tendai Chumi's words, The default manner in which contemporary national borders enforce exclusion and inclusion is racially disparate, and international migration and mobility remain racial privileges. The case of AAA, the Nationality and Borders Act, and the Illegal Immigration Bill all address who does and does not belong in the UK. They are, or to be more specific, who can and cannot make an application to belong in the UK. The effect of this, and I think is that we need to, the effect of this is that I think it's useful to think about how the classifications of migrant or refugee do not represent social groups as much as symbolize state-regulated relations of difference and state-manufactured conditions of vulnerability. While the rich from wealthy states can enjoy borderless mobility, as global investors, bankers, expats, or hipster tourists, racialized poor people are subject to discursive and material criminalization and illegalization. The effects of the combination of law and policy making seen in the Illegal Immigration Bill, the Nationality and Borders Act, and the Rwandan APA will not deter the movement of people in the future. All available evidence suggests that these types of punitive measures do not stop people in desperate situations from moving. What it will do is push people into more dangerous routes, as they'll try to land in the UK rather than be rescued in its territorial waters. They'll try to avoid detection by the Home Office altogether, entering the UK as the most marginalized of people, a workforce that cannot work legally, cannot unionize, cannot register at a GP surgery, cannot vote, and cannot access any state support. This scenario, I think, offers the legal foundations for building a global underclass of racialized and vulnerable people who will be subject to economic exploitation. So migration control is one of the sites of racial oppression. It's also one of the sites of potential racial redress. Tendai Achumi has made very interesting arguments about migration as decolonization. A broad and purposive interpretation of the Refugee Convention has the potential to enable the movement of people with very real redistributive outcomes. There is potential for a wider project of social justice based on migration and the movement of people, but such a political ambition cannot be fought in the courts alone. Reading the racialization of Rwanda in the 2 English courtrooms and the implications for legal change, both in Rwanda and in the UK, demonstrates how the engine room for this type of change has to be found in the political domain as much as within the legal one. Let me stop there. Those are my initial thoughts, and I very much welcome comment.
Thank you very much. The floor is open for